Good morning, Scott Boats here. I'm about to go live on TikTok, and the topic is judicial surety bonds. Judicial surety bonds are nothing new in the United States, but we've moved away from them for some reason. Some judges do have to have them, very few of them, but we need every trial judge across the United States, including the 680 or so federal judges, to start posting these. The idea is to give remedies to people. That's the idea, and this idea is supported by the founders of our nation in Federalist Paper 10. I would recommend that to everyone. This is not a controversial or strange idea. It's the way things should be and have been has been in the past. Let's see what we're doing here. Okay, let's do this. Okay. Well, good morning, everybody. Scott Boats here. I'm a lawyer. I've practiced law for a little bit in Texas since 1992 and graduate of U of H in the U of H Law Center, Houston. Um, I'm an outsider. I have an outside inside point of view. My family is very working class. My dad was a prisoner of war in World War II. Both my parents grew up during the Dust Bowl days, the Great Depression. Um, the way to get ahead, we were always told, me and my siblings, I'm the youngest, was to go to college. So I did that. I'm the first lawyer in my family. My siblings and I are first generation college. Um, Briefly, I served as a municipal judge in the city of Houston. So it's not like I don't have a concept of running a courtroom. I do. It was a very pragmatic situation. I worked night court and then I would do arraignment, um, Miranda warnings type stuff on the weekends at the jail on Makawa. I was a younger man. I'd take my daughter with me to the jail because the judge's chambers was so nice out there. And Anna, my daughter, was about 5, 6, 7 years old. I do the same thing when I had Anna. I was divorced since she was before she was 3. And at any rate, so I have an outsider insider point of view because I didn't want to be a lawyer so I could join a clique, and that's what law has become. And judges are at the top of sort of an elite club. So I thought what we'd do this morning is you'd let me kindly give you a breakdown on the history of judicial bonds. The idea of a bond is to create the opportunity for a remedy for somebody who's been wronged. Create a remedy. As a populist, I believe that all people need remedies, not just, the friends of the judges or the friends of the political class, where they're on the red team or the blue team, but normal people like you and me. And again, looking back at, the way I grew up, half my family loved FDR. That was my granddad who ran a farm in Oklahoma, and the other, I'm sorry, that was my grandmother ran a boarding house near Tulsa, and that's the lady from my daughter's name. They loved FDR, said that he saved the country. My other half of the family despised him. He brought socialism to the United States, my granddad Boats would say. Um, and so I've always had a foot in each party, so to speak. I try to stay true to my populist roots. I'm uncomfortable with all groups, even the partisan ones. I don't think anything good ever comes from a village, a community, a tribe. Those are all just synonyms for mob or mobs. Goodness and greatness is in the value of the individual, not the collective. And that's the way I look at what I do in family law. I'm a family law litigator. I love to represent dads. I'm a dad. I was dad of a little girl divorced before she was three. At that time, I was not into family law. I entered family law for other reasons, but my populism relates to everything in family law. And so this issue, control of the judiciary, and that's the way I see it, control of the judiciary by giving normal people remedies. It's very important to me. But also know that this is not an esoteric notion. It's been around before, but it was Bradley versus Fisher, an 1871, 1872 case that established what's known as absolute judicial immunity. But it's been misrepresented, as many things are by structures. The idea that judges should be free of accountability is absolutely contrary to Federalist Paper 10. Uh, when I went to college, I was a political science major first, psychology major second, then went to law school. Thing is, I always studied this sort of stuff, and I find it profoundly relevant today. So I want to give remedies. The idea is to give remedies to people, and it's consistent with our history. This was once a remedy for people. And likewise, it matches our origins. We had this remedy. It's been taken away, in other words. Now, look, we've got over 30,000 state trial judges. We've got 680 federal trial judges. It is offensive to suggest that all these people are wise sages on the hill. In this environment, it is offensive to suggest that they're nonpartisan. Every judge is a politician. Whether you face direct election, you run for the one party's nomination to be judge or the other party's nomination to be judge, and then you face off in November, or you get appointed by a governor. I was appointed by a mayor, and everybody, he'd been the former Democratic Party chair for the state of Texas. Everybody knows who everybody is within the system. The idea of nonpartisanship is a dangerous myth. It also allows judges to say, we're above the fray. We're above the political fray. No, they are not, especially now. All these particular issues that might divide uh, the parties, you see them. You see them in court in the biases of the judge. So that's the idea behind creating a remedy for you and me, normal people, through a judicial surety bond. It's the idea of an open culture, not cliques, not a caste system of lawyers and judges. And it's about bringing accountability and thereby structural change. The structure's been changed before. That's how we lost the judicial surety bond. Let's change it again by implementing it. I want to bring skin in the game for the judge class. Why should it be that the plumber who fixes, my shower, why does that person have more accountability than the judge? The judge, the local trial judge, has more power in our lives than the president of the United States does. I know we get caught up in these personalities. Oh, this president is this and that president is that, but it's all a distraction. Power is at the local level and it's wielded by judges. And all I'm saying is when they make a mistake and they cost you or my clients thousands of dollars, sometimes tens of thousands of dollars to fix, that judge needs to be accountable. Not personally. That will never happen. The Bradley versus Fisher makes that very clear. But through judicial surety bonds, you sure charge the bond for the damage. Look, the judge should have known. The judge is a former lawyer. The judge is charged with knowing the law. The judge should have known before they made that wrong decision. And so people should have the right to bring a complaint against the judge, not personally. It's through their bond. I just want people to be recompensed. I want a remedy. I want a solution to a judiciary that is, in my personal opinion, my personal view, not responsive to the people it's supposed to serve. Um, Judge makes a mistake, you're going to get a bill. That bill's going to be from your lawyer. The judge still gets their paycheck. Everybody just moves merrily on down the line, and the lawyers deal with hundreds, thousands of cases in front of a singular judge, so you just kind of move on from it. You've got to move on from it. You can't let what happened with one client a while ago affect what you're trying to do with another client right now. That's why, again, it's just this objective measure of fairness, a surety bond. That's what I'm trying to get done. So, I'm trying to break down the history for you today of these bonds, but let me define some terms. What is it that I mean? Well, judicial surety bond involves a principal, that's the judge, an obligee, that's you and me. All right. We are protected. We are protected by a promise. The judge owes the promise. And the promise ultimately is to do their job, faithful performance of their job. Often you'll see that in their oaths. They promise to faithfully perform their duties. Well, my God, if they screw up a default judgment, or if they issue an improper ex parte order or an unconstitutional gag order, or if they have a bad day and just throw somebody in jail under direct contempt without following the procedures, that messes up the lives of honest people. People have a right to an open court. The judge has just shut the courthouse doors by taking unlawful action and, again, run up your fees. The judge, I get it. Uh, the case law, and it's just reality. We will never, and you probably should never, have the notion, I'm going to make that judge personally pay. No, but I promise you, I assure you that if certain judges are tagged often enough on their bond, not only will the political class think twice about renominating that judge or these so-called blue ribbon panels who make recommendations to legislators and governors or the governor themselves. Everybody's going to think twice about that judge who keeps costing the taxpayers money. Now, why is it the taxpayers the money? Well, because the taxpayers are the ones who get the bond. But again, what you're doing, it's a worthy investment. It's a worthy investment. Otherwise, if you don't make the investment, I don't know. I don't know that the judge uh, violated black letter law because they don't like my politics or my client's politics. I don't know because they violated black letter law that they're either uninformed or they're just trying to make a ridiculous statement way outside the role of a judge and playing partisan like that. I don't know what's going on, but a bond sure does get us to the point where there's accountability and responsibility. So let's talk a little bit about the history of judicial surety bonds. Again, these are not new. They were simply taken away. In fact, in a minute, I'm going to show you how some judges they have them, but the trial judges, and I'm interested in the trial judges. This does not apply to appellate judges. It would be impossible to work that for many reasons that are beyond the scope of what I'm trying to do here today. But every trial judge, because that trial judge, you see, they're the ones who enter an injunction against you that keeps you from living or doing something. In one case I had, kept a guy away from his marital property for a month because the judge just didn't open a file and entered a default judgment. And then the guy came and hired me and we fixed it. In another case, this judge, um, who was specially assigned because, the judge is going to bring something special to the case. All the judge did was bring chaos. And so entered an order contrary to black letter law. And what did that order do? It took away a 3-year-old child. That's what the order did. It took away a 3-year-old child from a parent who'd worked very hard to get possession and the right to decide where the child lived. That's what that specially appointed judge did. Violated black letter law. Oh, but there's more. The judge did that in a secret hearing because, see, what happened is the opposing party contacted the judge ex parte. That means no one else was involved in the conversation. No judge, The canons prevent you from that having that conversation. But this specially appointed judge had that conversation. And then this specially appointed judge had a secret hearing where the client wasn't present. And that specially appointed judge entered an order that took away possession of this 3-year-old little girl. And it took 5 weeks to get a court of appeals to tell the judge, most respectfully, that the judge did not know the law. And so it got fixed. But look, you can beat the rap. You can beat the rap, but you can't beat the ride. What I'm saying is when a judge does something that inane, all right, that judge should stand accountable. Again, it's impossible to make it personal. And you can't sue your congressman, and you can't sue your senator. But you can take actions against a bond and you can get recompense. And that's what has to happen. Again, if that happens, everybody, everybody knows these judges that are screwing will screw up. Right now, they're anonymous. They're elected by a wave. Is it going to be the red wave or the blue wave? And some of these folks who just become judges, maybe in their 30s or 40s, are very young, not much life experience from my point of view. I'm 62. Not much life experience and not much legal experience. But they're going to be a trial judge. And the way they're going to do it is they're going to join up with the local political party that's expected to have a wave. And that is not merit. That is not qualification. That is I can't make it in the private practice of law. And so I'm going to see if I can get a job with the government where I can wear my black robe and everybody stands up when I walk in the room. And look, again, I remind you, my brothers and sisters who are listening, I've had that role. It's kind of cool. People call you Judge, Judge Boats. And then I had my law practice on the side. I'd go down to court. People say, Judge Boats, good to see you. And you know, it didn't mean anything. But, and that's when I kind of started to notice this really is kind of a caste system we have going on here. My father was a welder and a pipeliner. I come from a different background. I may enjoy Hobbes and Locke and James Madison and so forth, but the deal is, I'm a hick from the sticks, and I know when things are different in one place or another. So the idea is to help all the judges understand the differences. And so that's the history of judicial surety bonds. The problem became um, the case Bradley versus Fisher. The faithful performance standard has always been the basis of surety bonds for public officials. Your sheriff's got a bond. Again, I'll get to it in a minute. Lots of judges have these bonds. Faithful performance. In other words, if the judge doesn't open the file to see that there was no service and enters an order that prevents somebody from getting access to their property for weeks until we can get before the real judge, pardon me, I mean the elected judge, because that was an associate judge who did that. And of course, I wasn't representing the fellow at the time. He came to me immediately, and so I had a day to get something in because you got 72 hours to do something to get it reheard to get a motion of rehearing, and then you get in line to be heard by the elected judge on the rehearing. But when the judge does that, does not open the file, man, come on, that is not faithful performance. They're judges, but they were trained to think like lawyers. So maybe the judge needs to think like a lawyer, not a partisan who's afraid that, I don't know, they're going to have a contested primary. Oh my goodness. Is the other team going to have this wave and I might not keep my job? I don't know. I just want judges to act like judges, which means they think like lawyers. But at any rate, faithful performance has been the standard. The turning point came with Bradley versus Fisher in 1871. Again, these were common. It's a common law tradition to protect people um, because of what trial judges do. Uh, Trial judge can kick you off your own property. Trial judge can keep you away from your own property. Please go back through my TikToks and look at the videos on protective orders. You want to see uh, an indefensible situation. Look at the status of protective orders in family law courts. That's another example of a trial judge having the authority through an ex parte hearing. You're not there. You understand? Ex parte means you're not there to say your piece. And the other side gets an order, and you get kicked out of your house. You don't get access to your funds. You don't get access to your kids. You're living out of your car very often. Those are my clients anyway. They're living out of their car when they come to see me, and it's under a preponderance standard. Look, judicial immunity is a problem because what happens, we get these social movements, whether it's, I don't know, mothers against drunk driving, and I got it. We shouldn't drive drunk. Got it. I'm all with you. Or it's these social movements that maybe exaggerate domestic violence claims against strong, powerful women who are girl bosses. I don't know. Look, but the deal is that these social movements pollute the judiciary. And so the standard doesn't mean that much. And so whoever is on the other side, especially if they're male, that's my argument. This affects men more than it does women, especially if they're male. They get tagged and they're suddenly living out of their car until they can get a hearing. But so look, it's a problem. Bradley versus Fisher, absolute judicial immunity applies to judges of general jurisdiction. That's a trial court level judge. New York calls their trial level judge Supreme Court judges. I don't know why, but that what that really means is they're trial judges. Here in Texas, we're district court judges. Those are the trial judges. But I think this should apply to JPs all up and down the system. If you're a trial judge and you have the right to kick somebody out of their home, well, judge, I bet you're going to take it a lot more seriously if you've got a bond that can be surcharged, with all due respect, Your Honor. All right, and that's what this is about, creating accountability. Again, not foreign. The absolute judicial immunity was problematic in Bradley, but we went too far. It didn't happen immediately in the 1870s. It did kind of disappear by about 1940 for some reason. Let me give you a case study right now regarding Texas statutory probate court judges. Those men and women, they carry a bond. That is Texas Government Code Section 25.00231. Those folks carry bond. What's going on in a probate estate? Well, you're protecting the property of somebody who's deceased or incapacitated. So yeah, $500,000 bond. And it's conditioned on what? What are those magic words? Faithful performance. Well, look, what I'm saying is all judges have a duty of faithful performance. Performance doesn't mean giving one litigant more consideration than another because they're, they have high standing in the community, or they're this sort of activist, or they've been in this group. All right. Faithful performance means you treat everyone equally. Probate judges already have them in Texas. Again, these are not that unusual. It's just this that Bradley versus Fisher is misinterpreted. And of course, nobody pays attention to Federalist Paper 10. Federalist Paper 10 talks about the problem with factions. That is political parties. It doesn't matter whether it's the Lullaby League versus the Lollipop Kids. All right, those two factions. All right, and that's kind of what we have now. One is the Lullaby League, and the other is the Lollipop Kids. And you can probably figure out the gynocentric one is probably the Lullaby League, and then the rugged individualists are the Lollipop Kids. But at any rate, look, those are factions. And from the very beginning of the Republic, the greatest republic in the history of mankind, greatest republic in the history of mankind. Our revolution meant something. French Revolution fizzled out. Nothing became of it. Lots of people lost their heads. But greatest republic of all time started out with the idea of accountability for all branches of government. Not that one branch of government would be a shadow. Who are these judges? I don't know. I live in one county and I practice in about four different others. I don't practice in the county where I live. And so when I drive home, I see all these signs. I wonder, who are these people? Because I know they're practitioners, but I've never dealt with them and I don't know them. But again, my bias kicks in, and bias kicks in and says, well, these are all lawyers who have given up on the private practice of law. I don't know for what reason, but they think they can now be a trial judge for my clients. I don't know. Maybe so. Maybe they'll be great trial judges. They're running, as Republicans or Democrats. I don't see how that should make a difference, but it does. I mean, in terms of who gets elected. So they will judge my clients. I just want them to follow the law and not do something that screws up my client's case, including, this is a topic for another time, including appointing their favorite amicus attorney or their favorite guardian ad litem or their favorite therapist so the family can get better. Okay. Um, I just want the judge to stay in their corner. I'm the one with a private contract. I'm the one with a private contract with a mom or a dad, or frankly, with a plaintiff or a defendant. Judge, you're calling the balls and the strikes. Please don't screw up this situation any more than you have to by appointing your favorite. I don't know if they gave you a campaign donation. I don't know if you're just virtue signaling and because the way they look. Is it the clothing they wear? Is it something else? I don't know. But how do they get appointed again and again and again and again? I'm just looking for remedies for people, looking for remedies, and that means accountability. So, what are the arguments for requiring bonds for these trial judges? I think you need a financial remedy. When a judge screws up your life, and they screw up lives all the time. Remember those numbers. Over 30,000 state trial judges. Over 30,000. 680 or 70 or something like 680 federal trial judges. Stop. Those are not wise sages on the hill. Those are people who got to where they are because they know the right activists, they know the right congressman, they know the right senator. They are partisans, okay? They are not wise sages on a hill. There's nothing inherently objective about any of them. They have taken a career path which enables them to get to a position. They can be elected as a Republican or Democrat in some states. They can be appointed on a nonpartisan basis in some states. They can be elected on a nonpartisan basis in some states. And they can be appointed. They can be appointed by that blue ribbon committee. Yeah, right. Recommended to the legislature, or recommended by the governor, I guess, and the legislature appoints. Those are the basic ways that we get our judges. In Texas, we elect them Republicans or Democrats. And so we have waves. If it's a Republican wave, a bunch of Democrats will become mediators again. If it's a Democrat wave, a bunch of Republicans will become mediators again. And so, because they get tired, I think they get the practice of law may be too difficult. I'm just putting it out there. I'm not judging, but it seems like that's what happens. So, look, we need accountability. They need to have a skin in the game, and you as a victim must have compensation. Judges do become predators. You do become prey to a judge. I know you, some of y'all know that because we've had conversations, whether it's, several guys in Florida, several guys in California, Illinois, Maryland, Oklahoma, Arizona, New Mexico, of course, here in Texas. There's just this widespread judges gone wild. And I don't know. I wonder. I mean, is the quality of the education that bad in universities and then now law schools? I hear that the ABA is recommending that law school go down to 2 years, which is stunning to me. But yeah, let's just get them out. They're not very smart anyway, and then get them a law license and turn them loose on the system. And inevitably, though, what they do is they defend the system. They defend the system by using the system. All right. So the system is dysfunctional. And so if you bring more and more people into it to use it, the system has artificial validation because all these people are using it. That's why the system has to be fixed. And normal people have to be given remedies. There are other changes. The system needs to be open. This whole idea of special jargon for courts. I see these embarrassing videos where these judges kick people out of court because they're wearing overalls or jeans. I don't know what that is, but except a disgrace. But we've got to bring these judges under control by creating remedies for people, and that's the judicial surety bond. At any rate, give them skin in the game. Now, why? Why bond trial judges but not appellate judges? Look, appellate judges apply the law. Trial judges, subjectively, with discretion, interpret facts. All right, that's the devil in the details. Why, why is one conduct in one court just conduct? And when it's done before a different judge, it might get you direct contempt. And this insane, sane counsel, I hope you brought your toothbrush because the idea is you're going to jail, okay? Why is the conduct one way in one court and another way in another court and another way in another way? Why? Because discretion. You want uniformity, and it'll be the best kind of uniformity. People who know the law, who are judges, and apply the law as judges. Give them some skin in the game. So the appellate judges got it. True referees. They're grading the papers. They grade my papers. All right. I know what it's like. It's uncomfortable. You know that appellate judge is going to be grading your papers. Trial judge, I get it, but you're just human, so act like it. And one thing we as humans have to do is show humility. You show humility, and certainly the idea of understanding the need for a surety bond is part of that. So yeah, that's why we must deal with the trial judges as opposed to the appellate judges. You know, those Texas statutory probate court judges, the trial judges, all right, they've got surety bonds. So some judges already have them. This is not a revolutionary idea. It's just an idea that is resisted by the system because, in my opinion, both the judges and the Bar Association, that sort of law class, unite together to make the system difficult to enter. Again, it's partly the jargon, the nomenclature, the language. Partly it's the rules, it's the procedures. Um, you should, I don't believe that any mom or dad should have to have a lawyer to go to court to seek primary custody of their child. But I also don't believe, and I know this is putting a lot of pressure on these judges, I don't believe that a judge should just appoint somebody into the equation, a friend of the child, an amicus. What happens is they take control and they do it under the context of, the judge appointed me. We have to have systemic changes. Surety bonds are part of them, and then changes of the system are another part of them. And so, um, changes in the system are part of it, but the impediment is the judge class, and defended by the lawyers for whatever reason. I don't know. I don't know why lawyers don't do a better job. We don't. The Bar Association is not a union for lawyers. It's just a required organization we must join to practice law. It's not a union. In other words, it doesn't represent the interests of lawyers. And I assure you, most of us who are lawyers practicing, going to court, we have the interests of our clients first. There are plenty of lawyers who will tell you about the need to assure accountability by judges. But again, if you're a lawyer and you're going to be in front of a judge hundreds of times, thousands of times in your career, my friend, you simply can't look back to the client 1,000 times ago, 100 times ago, and try to fight their battle now when you have another individual who has to have effective advocacy. So that's the challenge. But there's the bar associations are not a union. That's one of my problems with the family law section. Look through my videos, please, and take a look at the problem with standard possession orders. Absolutely indefensible that of a child has no guaranteed access to their child for the first 3 years of that child's life. I could say, well, there's social Marxism for you. I could say something else, but it's just ridiculous. Does the family law section say anything? No, the family law section gives themselves crystal awards, probably paid for with my bar dues. But there's no effort to bring equal protection for men and dads in Texas. It is absurd. But that is the nature of law and the judiciary there's a tendency to form an illicit relationship. And illicit, by the way, you bet you can read that many different ways. You better believe it. The two people who've contacted me from California, where the judge has that special relationship with that special lawyer, I wish I could say that I'm surprised, but I've been doing this th almost 34 years. I'm not surprised anymore. But the thing is, it's an illicit relationship, and that it doesn't serve the greatest good for the greatest many. It serves a clique, a class, um, a caste. It's a caste system. You're either in it or you're not. Look, what people are going to say is, "Oh, you're going to destroy judicial independence if you make judges." I shouldn't mock them, but if you make them post bond, judges are going to be scared. You won't be able to get good lawyers to serve as judge. Man, get a grip. You will at that point get good lawyers to serve as judges. You won't get these wave riders, these wave runners, the blue wave or the red wave, and they haven't practiced law for any meaningful amount of time. And the deal is, though, they know precinct chairs or whatever. And again, that's how too many of these people, sorry, buddy, um, too many of these people get their jobs. So the logic is that, uh, look, bonds don't tell judges how to rule. It ensures they follow the rules. It ensures they follow the rules. Judges are former lawyers. They're charged with knowing the law. I promise you, there's a chance if you ever walk into a courtroom, the judge is going to get it wrong, and it might not be. I don't know. I don't know that they actually don't know the law, or they're just acting out of bias. As trial lawyers, we have two primary tools against a judge who is problematic. One is disqualification. Disqualification just means conflict of interest. You're shooting fish in a barrel. Is the judge related to somebody or not? Does the judge have a financial interest in the outcome or not? Fish in a barrel. What's interesting is recusal work. Recusal means bias, um, uh, and from my point of view, what's the best word? Well, they don't know what they're doing. They're incompetent. That's what recusal is. So a few years ago, I got on this uh, pattern. I had three different recusals. One went to a hearing, and the judge got recused. Just a partisan actor. Predictable that she got recused. Another one forced the judge out, and so just a tactic for motions. And I'm not going to talk about it, all right? But the deal is that never give up. Never, 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 never give up. All right. You persist, you persevere, you take your time as a lawyer when you've got an objective. But it paid off. The judge went away. And it was based on, look, it came down to incompetence. God bless everybody. But if you don't know the law that you're asked to apply, and it shows in what you're saying in your hearings, um, well, it's open season on the judge. That's recusal. So we have disqualification and recusal. There are going to be limits. There are going to be limits on recusal. Why? Well, a cynic might say it's the judge class or the lawyer class taking care of itself. Right out of the bat, you can be an improper recusal, and you'll get sanctioned. You'll pay the other side's fees. I don't like that at all. And then there's also a third strike. On a third loss, the other side gets their fees. I like that because what's going on there? That's gamesmanship. You just don't like the judge. And what you don't like the judge is you're losing. You don't know the law, you don't have the facts on your side, and so you're just trying to get rid of the judge like you're just an insolent child. You're having a hissy fit, and it could be pro se, it could be a lawyer, whatever, and so you just bring an action, and you bring an action third time, denied fees. I love that. All right, but I was talking to a pro se up in North Texas recently, and she got tagged with the other side's fees on the first one. Now, let me just go into this for a minute. What was the disqualifying factor? It's 8:09 here, so I've got 20 minutes to go. I got an appointment at 9, and so I'll stop pretty quick. But here's the deal. Look, we deal with this all the time, and our culture, we got. Some would argue for a long time we had a Christian culture, and then the big word was Judeo-Christian culture. Sometimes people call it Western culture, whatever, Western legal tradition, et cetera, et cetera. Well, we got some new folks here, and sometimes they want their own courts. Problematic, all right, problematic. But I had a situation like that. I believe we have a culture, a multiracial society. That's the way I look at it. I don't know that I want a multicultural society. Multicultural implies that there's something ahead of due process of the law and equal protection under the law. Multicultural implies that the first 10 amendments to the Constitution can be changed because you get offended when your point of view about the unknowable is offended. Um, you can't do that. We can't be that nation. We're suddenly not the United States of America anymore, okay? And so, as a trial lawyer, that bothers me immensely. Of course, we're multiracial. Of course, we are. Multicultural? Really? I mean, you think that you can suddenly reverse where we've come from in our history in terms of rights to all groups? Uh, Problematic. But I had that case. But the person was going at it pro se. And, I thought, she's brave. Good for you. Take on the judges, show bias. But she got tagged with the fees on a recusal. I don't know. It's from a county that I'm mildly familiar with, and I get contacted from that county a lot by different people. But at any rate, it had to do with, she just wasn't a member of the group, and everybody else was a member of the group. Is that a problem? Now you think of a group, all right? And you're the only one who's not a member of that group. Well, the judge is a member of that group. The opposing lawyer, and there was an opposing lawyer, the other side was not pro se. That lawyer is a member of the group. Oh, by the way, that opposing lawyer is on the judge's appointment list for just about everything. My goodness, that judge keeps that lawyer busy. Um, and then Importantly, the opposing party likewise, in other words, the opposing opponent to the pro se I was talking to, I don't want to get too deep into this, was a member of the group. You're the odd man out. Do you bring recusal based on that? I say you do. I say you do. I think you make the case, you do your homework, because the judge class and the lawyer class is going to be anxious to team up on you and tax you with fees. But you got to do it. You have a responsibility to do it. Why? Because our courts are too partisan, insanely partisan, and the judges are oblivious to it. At any rate, so people also say that this will lead to frivolous lawsuits. No, it won't. No, it won't. No, it won't. This will actually lead to meaningful lawsuits when you have skin in the game. Again, what are you trying to do? Improve the judges. There are no frivolous lawsuits from this stuff. Okay. Judges won't be able to afford the premiums. Well, the public pays the premiums. That's the way it is. Public pays the premiums. Here's a good thing. Judge gets tagged on their bond that the public has paid for. I think that judge goes away. Okay, that's good. And either the partisans with the local club, political club, say you can't run this time, or the voters get word of it. And more often than not, I've got a statistic here that I probably won't get to, but it's impossible to get rid of an incumbent judge in any circumstances, whether partisan elected, nonpartisan elected, appointed by the governor, appointed by the blue ribbon council. You can't get rid of them. It's and federal judges, by the way, you literally can't. I've got that here by the language of the Constitution. The judge who's going to hear the case involving the head of state of Venezuela, that judge is 91 years old. And yeah, there, by the way, in researching that issue, there is one judge who's subject to a conservatorship hearing. And as far as I can tell, that judge is still sitting as a federal judge. Understand what I'm saying. People are trying to get a guardian, a conservator appointed for this federal judge. And I don't know, maybe the individual has died by now. I don't know. But from what I could tell, it's still going on. They're a federal judge. You can't get rid of them. There's not going to be a constitutional amendment passed getting rid of this lifetime appointment stuff. That's why, more than ever, we need judicial surety bonds for these trial judges at the federal level. Maybe Congress will do something about it. There have only been 8 impeached federal judges in our history. Only eight have been impeached in our entire history. There are 680 judges now. 8 have been impeached. Yay! That's a system that does not work. The Congress gets rid of the federal judges. The Congress won't ever get rid of federal judges because of partisan nonsense. Okay, the red team will be loyal to the red judges. Blue team will be loyal to the blue judges. Who are the judges? Trial court judges, federal level. 39% Republican, 61% Democrat. Supreme Court of the United States, 6 appointed by Republican presidents, 3 appointed by Democrat presidents. It is reasonable to say it's 6-3 majority to the red team at the Supreme Court level, but a 61-39 majority to the blue team at the federal trial court level. I don't that might be interesting to some of you who note these nationwide injunctions that are issued. Maybe it's not. I don't know. I'm just going to put that out there. But I'm sorry, 15 federal judges have been impeached by the House of Representatives in the entire history of the United States. Eight have been convicted. That means they got rid of them. Yeah, there is that federal judge who is the subject of a high-profile judicial disability proceeding. I do apologize. It is not a state guardianship proceeding. It's a judicial disability proceeding. And by the way, my query to LexisNexis deals with, have any judges ever been the subject of involuntary mental health proceedings? That's a commitment. I used to do that work in Harris County, but those are some very ill folks. And the answer is no, to my mild surprise. Anyway, over 4,200 individuals have served as trial court judges in the history of the Republic at the federal level. Again, 8 removed from office, a total of 15 charged by the Congress, impeached. Remember, impeachment means you're charged. Trump was charged twice by the House of Representatives, never removed from office, right? The Senate removes. All right, so what are they saying here? The House of Representatives charged, I guess, 15, and then Senate agreed on 8 during the history of the Republic. Are you serious? Grow up. I mean, stop. Leave your partisan nonsense behind. Leave your loyalty to the bar, to these weird structures behind. 4,200 appointees, only 8 removed. Because don't you know, the other 3,992 are wise sages on a hill. Yeah, that happens. Stop that nonsense. At any rate, those are our federal judges. I've got some statistics, other statistics here on the state, but all of this relates the notion of a surety bond for judges. It relates to their oath of office. We talked about the one standard, faithful performance, but they also swear that they're going to support and defend the Constitution of the United States. By golly, Judge, if you're going to support it, I think you ought to know it, don't you? Don't you think that's reasonable, ladies and gentlemen of the jury, that the judge ought to know the Constitution and apply it? I mean, they say they're going to support and defend it. In there, support and defend, don't you think you can find the word apply? I don't. I think I may be misreading it, but the, I tell you what, the Judiciary Act of 1789, that's the beginning of this republic. Effectively, we were ruled by the Articles of Confederation. That's the importance of the Federalist Papers came along and said, we got to fix this. We got to make a government that's effective. 1789, the beginning of this republic. What happens? Well, federal court clerks and marshals post a bond. How about that? Let's get your boss to post a bond too, your boy boss or your girl boss to post a bond. Um, so why do we bond the person who files the papers? That's the clerk, but not the person who has the power to mess up your life by misapplying the Constitution or the laws. I don't know, but we need to do it. We need to start bonding everybody. And I don't exactly know how we do it, but I do know that change begins with conversation. So, my friends, we got to start talking about this. We got to start talking about the need for bonding judges. Let's stop being serfs. Let's stop being serfs. Judges are not fief lords. Judges are just judges. And when they start posting bonds, they will be reminded that judges are just judges. Like, we're just all folks. And so let's break the partisan shroud. Let's move from anonymity to agency. You have responsibility now, Judge. And let's tell you what, let's show up for work on time. Let's stay till 5 and let's work hard. And then you can go home like the rest of us, okay? Because you got a lot to do work to do. And I know I'm thinking about a couple judges right now who are some of the hardest working judges I've ever met. And I've known a lot of good judges. I was a working class judge, a municipal judge in Houston. I know what it means to bust your butt to be a good judge. All right. But some of these judges, oh my God, they are driven by ego. Let's move from anonymity to agency. Dismantle the shadow government. All right. I don't know who these people are. You don't know who these people are. They're hidden. Why are they hidden? Because their wrongs are never brought to light. Nothing brings a wrong to light better than putting a financial cost on the wrong. The bond solution is a private check on public power. We pierce the veil. These obtuse rules and the cost of justice is too expensive to get. I get these things from guys all the time in my feed my social feed that I don't have $5,000. I don't have $10,000. Brother, I got you. I understand. It shouldn't be that way. We're talking about our kids. We're talking about our kids. Change begins with a conversation. It's not going to start with the family law section because they're giving each other crystal trophies, okay? They're just not going to do it. And they have for decades. I'm new to this area. I started in this area about 2013. I had a child custody modification, 2 in a row I had to deal with. And like a lot of y'all, I hired a lawyer. And you know what my lawyer did? My lawyer didn't show up to court. So I got to tell you, my brothers and sisters, that the Lord makes the rain to fall on all of us. My lawyer didn't show up to court. But I handled it. It was okay. But the deal is, I'm kind of new to this. But the more I've seen it, so in the past 13 years, I come from a criminal defense background and a guardianship and estate background. Yeah, I've dealt with some civil litigation. I worked with a lawyer who had a name, and she would get all sorts of cases just because of her name. And so I've dealt with all manner of cases, but she understood because she didn't drink the Kool-Aid, whether it was red or blue, that there's something wrong with the family law bar. I mean, they just too willing to go along to get along. They go along with parents' patriarch powers exercised by family court judges, and family court judges don't have parents' patriarch powers. Guardianship judges do. But anyway, they act like they do, and they say, "Oh, my main interest is the child." No, judge. The interest of my client, who's a mother or father, their interest is the child. Your interest is to call the balls and the strikes. And please remember, do as little harm as you can. Don't appoint somebody to mess up my case. I have a private contract. They came to me, and Judge, you're exceeding your powers as a referee by bringing your friends into this equation, with all due respect. So here's the deal. I've practiced law for a long time. You can tell I'm a partisan, power to the people. I'm not a collectivist. I despise collectivism. It kills human freedom. Kills creativity. The guy who said that collectivism is warm, what he means is that he was probably in a prior life somebody who burned the witches or burned creative people, because that's all collectivism does. It destroys creativity because you got to get along, get in line, and go along with the mob. Or, like, I guess that mayor, he's going to burn you at the stake. I don't know. I think that's what the warmth of collectivism really means. It's not cold to be an individual. You can form an impersonal individual relationship with your God that way. That's the way I do it. It is a personal relationship. It's not based on tribe. It's not based on what I do for a living. It's not based on this silly stuff about politics. Oh, I'm a this, I'm a that. Although I did say I'm a populist. At any rate, look, I believe in power to the people, and that's all this is about. So I'm going to keep doing this stuff, and I'm going to pivot just a little bit. Um, and next week, what I'm going to do is a live on social Marxism in American courts. Now, my most current background is a family lawyer. There's no more herd mentality, village mentality, community mentality, mob mentality than in family court. That's my beef with the folks. Is everyone, it's groupthink. Again, please do a couple things for me. Look through my TikTok videos so you can see where I'm coming from. If you're inclined, go to YouTube and subscribe if you would. You want to talk to me, you want to engage, send me an email, okay? I will reply. I sure will. How do you get my email? Go to my profile. It's the red email button. I tried it before I got on here. There have been some people who wanted to co-host. I don't know what that means. All right. I'm new to this, but thank you so much. I so much appreciate your interest in this topic. Social Marxism. Why is social Marxism interesting to me? Because social Marxism is the absolute antithesis to the spirit of the Federalist Papers. Again, what is the Federalist Papers? They were a PR attempt to change the structure of the American government from the Articles of Confederation, a weak federal government, to a more unified group through the Constitution we have now. I believe in the first 10 amendments to the Constitution. Take a look at them. Do that. Just Google Bill of Rights and take a look at them and see look at the rights you are guaranteed. Government doesn't give them to us. Government restricts itself. Government restricts itself from imposing on those rights. Now, I don't know what happened to the Fourth Amendment other than the Patriot Act and Ruckus versus Illinois and other cases, but look, it is what it is. But we've got the First Amendment, thank God. First Amendment matters because you can talk to people like me. I believe in absolute free speech. I associate with who I want to associate with, and you bet I have my own personal relationship with God. That is where we get the notion of freedom of conscience. So all these people who want to restrict free speech, whether they're a lobbyist for some foreign government or some foreign official, they just don't get it. They come from a land of tyranny and they don't understand that many of us will not go quietly into that darkness of tyranny. This started, remember, we had judicial surety bonds. Our system is a mess because of systemic changes. Let's make more systemic changes. I've got other ideas, but this is a part of those ideas. Scott at boatslaw.com, or just hit the little red button. Thank you for wanting to co-host with me. I just don't know what the heck that means or what I'm giving up if I do that. Federalist Papers and social Marxism going to come up. We got to start talking about gynocentrism. Gynocentrism is prejudice against men. Prejudice against men and dads in this culture, all those stupid social tropes about, men are ridiculous and oh, don't we need women to do everything? Good God Almighty. I don't know where that comes from, but gynocentrism is problematic. There are judges who seem to embody it. So that's going to be something I talk about. A Bill of Rights for men and dads, something I'm working on. We had a Bill of Rights in Texas for kids. There's too much emphasis on the point of view of children. That's why they're children. You really want the 6-year-old to give a point of view. That's a prime age for not knowing anything and also just learning to manipulate people. No, we have to put parental rights way ahead of what the kiddo has to say. Remember, judges, don't mess up our cases. Hold on to your point, your friendly appointee, until you absolutely need it. Thank you so much. Um, those are the topics that are coming up. Send me an email if you'd like to talk more. God bless you. I appreciate it. That was TikTok Live. Never done that before. We'll see what happens. My client isn't here yet, so that's judicial surety bonds. I don't have anything against judges, love judges. I had an opportunity to do it full time twice in my life, and I said no both times because the action and the meaning is right here where I am now as a practicing attorney. And so join me next time, and you're welcome also. Send me an email if you'd like to chat. Scott Boats, Scott at boatslaw.com. God bless everybody.